welcome everybody. It's just so great to see so many faces here, colleagues from Notre Dame, current students, past students, friends from afar, as well as many new faces who I'm eager to get to know, and I'm grateful that you're all here. For those of you in the United States, I'm even more grateful that you're willing to do so on what is a national holiday in the United States. That wasn't originally our intention, but we just sort of overlooked in the lockdown, you know, the rhythm of the semester and our days. So that you're willing to take a couple hours out of a holiday to be here makes it even more, something we're even more grateful for. Of course, as Anibal said, we would have loved to welcome you all here in person at the Kellogg Institute and spend our meals together and make this a time of fellowship in a much broader sense beyond the intellectual exchange that we'll have for the next 2 hours. And I hope very much that, you know, in a not distant future, we can welcome you here in person for exactly those purposes. But in the meantime, you know, we have a really rich day today to begin to share these things. I want to say just, you know, a couple words of sort of background to this, since this is the first significant, you know, more public event of this research initiative that Diane Desieto and Anibal Perez-Lignan have put together with collaborators. It is one of 4 new initiatives that the Kellogg Institute has created in the last year, which collectively we refer to as our Policy and Practice Labs. This one is in partnership with the Clough Center for Civil and Human Rights here as well at the Keough School of Global Affairs. And the point of these labs in general, as the laboratory sort of, you know, moniker suggests, is certainly, you know, because we're a research university, to produce high-level academic research that generates new and important knowledge, but beyond that, to do so in a way that creates knowledge and disseminates knowledge that is more immediately actionable among practitioners and policymakers in these spheres. And in order to do that, to engage in work that not only is academic in the strict sense of internal to university life, but that engages and incorporates in a very significant way other partners beyond the academic world in generating that knowledge and doing that research. So as I said, we have four labs that are doing that. I will confess, however, that this one of the 4 has a special place in my heart as we're doing this. Although, you know, I have to have a sort of kind of paternal regard for all of them, I suppose, as director of the Institute. But, you know, this one is my field. It touches on, you know, years of experience that I've had and observations that I've had about the challenges of implementation of human rights law. And it addresses, I think, at least in my assessment, a very serious contemporary challenge in the field of human rights generally. A field that, you know, I perhaps not all would agree, but I am one who frets a little bit about you know, what might reasonably be regarded as certain crises in the field of human rights at the moment. We could talk about those challenges in more detail. I would say that certainly one of them, one of the principal ones, if not the major one, in my view, is the rise of new forms of authoritarian governance in the world. And that, you know, claim a certain kind of legitimacy to their models, a claim of legitimacy that bypasses human rights and liberal constitutionalism and limited government, and many of the core principles that have grounded the human rights enterprise for the last 75 years. So that is something urgent to be addressed, and in an important way, I think this Policy and Practice Lab gets there, because one of the challenges, or one of the ways in which I would say skeptics and doubters of the human rights enterprise make a case, and it's not always in bad faith that they do so, is to simply say, well, you know, there's a certain fatigue and there's a certain cynicism that has come from the multiplication of instruments and institutions over many decades, and a sincere question about, well, what difference do they really make in practice? And is the difference actually proportionate to the effort that we've made to construct these and to operate them and the resources we pour into them? Well, those of us in the field know that they do make a difference. We've seen it, we've worked in it, we've seen the results. But it is a legitimate question to say how much difference, and more importantly, why and how. Where do the institutions that are trying to advance and protect human dignity have success in reaching decisions that are then capable of having an important impact on the practice of states in protecting human rights? And when don't they? Under what conditions, under what circumstances, over what period of time? These are among the range of questions that Diane and Anibal in this lab are trying to find an answer to together with their collaborators. And from that knowledge to, in a very direct sense, help arrive at the better design of reparations measures and plans and strategies over time. And in doing so, I believe this goes centered in human rights institutions, really goes to the heart of international law more generally. Is knowledge that is going to help us, bring more coherence and unity to compliance with and implementation of international legal norms across the board, I think. So I'm so glad that they have all of your insights, experience, commitments, knowledge, and expertise to draw on and rely on. And I'm going to be a very eager, certainly observer, participant when I can throughout the life of this lab, and including today. So welcome again, and I'll turn it over to Anibal and Diane.
Thank you very much, Paulo, and thank you to the participants in this workshop. First and foremost, we are grateful that notwithstanding these exigent circumstances that everyone faces around the world, that you are here, we are all here, ready to combine our experience, our expertise, our research to come up with guided answers that could helpfully, or rather hopefully be helpful to practitioners as well as to the institutions, but more importantly to the victims who are most concerned with reparations. We circulated the concept note to everybody and thus explained why we have, from our standpoint, focused on one example of state responsibility-driven reparations and another example of international organization responsibility. Anibal will later on proceed to discuss the methodology in encapsulated form. But for now, for purposes of beginning this workshop, let me first thank the experts group who are present. We have Ms. Lucia Aguirre from the Inter-American Court of Human Rights and Ms. Amelia Brenes as well from the Inter-American Court. We have Ms. Dilek Barlas from the World Bank Inspection Panel, Chair Imrana Jalal of the Inspection Panel, and Mr. Serge Selwan of the Inspection Panel. We also have from the Open Society Foundations, Mr. Christian DeVos. We also have from the Inter-American Commission on Human Rights, Ms. Fernanda Dos Anjos, Mr. Daniel Garcia, and Ms. Gabriela Pacheco. We have from our colleagues in academia, experts themselves in international law and human rights, as my director of the Kellogg Institute, Professor Carrozza, and then we also have Professor De Silva from Concordia University. We have Professor Marko Milanovic from the University of Nottingham, Professor Mary Ellen O'Connell, also here at the University of Notre Dame Law School, Dr. Francesca Parente at Princeton University, Professor Emilia Powell, also at Notre Dame, and Professor Naomi Rotariazza from University of California, Hastings, and Professor Frederick Surgens from Washburn University. To proceed, everyone has received a copy of the concept note, and that concept note has already been circulated in advance and is also available on the website. We have, for purposes of this preliminary meeting, as Paulo said earlier, this is mainly a preliminary meeting where we will begin to flesh out some ideas for possible collaborations. We will look at, from our end at the lab, we look at three possible core questions on reparations and compliance in the international system. And these are drawn on our own research, but also from the pedagogical aspect of what the lab does, where we have already run 2 classes, one on compliance with international decisions and another on human rights reparations. These are 3 questions that are now animating the direction of research and collaborations with which we have broadened and defined the trajectory of research for the lab. I must also mention that here present are some of the very first students who have worked with us at the lab and who are accordingly also acknowledged on the webpage. So for the first question, we are concerned with the question, how do tribunals conceptualize and implement reparations for international injury? Do they rely on pre-designed formulations such as in the ILC articles, such as restitution, compensation, satisfaction, or non-repetition? Or do these tribunals design bespoke reparations motu proprio on their own initiative or upon the petition of parties to a dispute? The second question, what factors determine the effectiveness of reparative judgments, decisions, or orders vis-a-vis the efficiency of their delivery for injured parties? Third, given current paths for institutional reform at various tribunals, what possible reparative reforms could also be considered? We undertake this research cognizant of the fact that various international dispute settlement mechanisms, from the World Trade Organization to the International Court of Justice to international criminal courts, as well as to the International Human Rights Courts, are considering the questions of effectiveness, efficiency, legitimacy with respect to the reparations that are conceptualized and implemented for parties availing of the dispute settlement process. And to this end, let me turn over to Anibal with respect to the methodology, the common methodology that we have employed to begin to plumb the questions that are that I've laid out here.
Thank you, Diane. The methodology for the Reparations Lab is based essentially on 2 principles. As you saw in the concept note, the first principle we are embracing is what we may call specificity. That is, rather than measuring compliance at the level of targets, for example, states or specific cases, we will measure compliance with specific reparative measures ordered by tribunals, broadly speaking. So for example, in this hypothetical example, we observe 4 measures belonging to 2 legal cases referring to the same target, for example, the same state. The second principle is temporality. We plan to measure not only if compliance happens, but also when it happens. So in this hypothetical example, again, the target complies with the first and the third measures ordered 2 years after the tribunal's ruling. It complies with the second measure by year 4, and the last measure, as you can see, remains open, right? Now, the important idea here is that this type of information allows us to model time to compliance. So in our data sets, we assign a score of 0 to every year when a measure remains open, and a score of 1 when compliance takes place. And the interesting idea here is that the average of those values provides an estimate of the annual probability of compliance for any set of reparation measures. So for example, the probability of compliance for this target is overall 17% per year. That is, we observe 3 events of compliance in a total of 18 reparation years. So translated back to time, this means an expected time to compliance of 6 years on average, including the information for the reparation measure that never experienced compliance. The advantage of this method is that we can also calculate the rate of compliance over time, that is, across cases and across reparation measures. So in this example, again, the rate of compliance, as you can see, tend to go up in the second year after the ruling, and again in the 4th year after the ruling. So with this approach, we can map the life cycle of reparation measures. So let me show you, for example, the life cycle for reparation measures ordered by the Inter-American Court of Human Rights. This is based on our analysis of 257 cases in which the court ruled against the states. In the horizontal axis in this graph, you can see the number of years elapsed since the ruling, since the court issued the ruling. And in the vertical axis, you can see the estimated probability of compliance based on the method I described before. So the probability of compliance grows consistently, as you can see, during the first 3 years after a ruling, and then declines. We observe a bit of a minor increase in compliance after 15 years, which, by the way, this is an interesting pattern that we also observe for the Inter-American Commission, as some of you know. And what is interesting here is that data for this life cycle suggests that there is a window of opportunity to promote compliance for the Inter-American Court in the first five years, let's say, after the ruling takes place. So I don't want to take a lot of time, but we can use statistical models to predict when compliance is more likely. And so in principle, we anticipate 3 lines of analysis based on this approach. The first one will be analysis of contextual conditions that facilitate compliance, but over which tribunals have little control. For example, government changes. The second type of question would be an evaluation of tribunal strategies. For example, the timing of supervision hearings, to assess which strategies are more effective in promoting compliance. And we are particularly interested in that. And finally, of course, we look forward to an analysis of the design of reparation measures, as Diane mentioned before, to assess the effectiveness of different designs. Now, I just want to emphasize that for this work to be meaningful, we need to work in collaboration with adjudication bodies and with colleagues in an interdisciplinary way. And for that reason, we truly, really appreciate your participation today. Thank you.
We now briefly turn over the floor for questions. I see Professor Surgens has raised a hand.
I just had 2 quick questions from the methodology. How do you deal with partial compliance and contested compliance?
That's a very good point, and I'm sure Diane will some points to add about this. Partial compliance and contested compliance depends a lot on the specific tribunal or adjudication body and how they assess compliance in each case, and that's why it's very important for us to hear about this later. For example, in the case of the Inter-American Court that I was describing before, the court in the supervision process identifies full compliance with reparation measures and partial compliance with reparation measures. So we can identify the timing of partial compliance such that we can model not only the timing to full compliance, but also the timing to partial compliance as well. And in fact, the life cycle I showed before, that probability over time was the probability to the first event of compliance, whether it is partial or full. So we can accommodate partial compliance in different ways.
I have other things to add to that, but let me first call on Dr. Parente and then we have Dr. Steininger.
Hi, everyone. So I also had a question on the methodology, specifically the aspect of temporality, because you know, I don't know how much sense it makes to average across all of the zeros and ones, because those are not independent observations, right? Because you would only ever observe like the outcome in year 3 conditional on there having been non-compliance in year 2. And so that sort of suggests that I'm not sure, I think this might need to be some sort of weighted average. It doesn't necessarily make sense to me to just aggregate across because these are non-independent observations. The other sort of measurement thing comes in the, in generating that life cycle, because I've noticed that pattern too. And I'm not sure how much of that is because, you know, they're actually, I mean, I do think there must be something to like, you know, 5 years being the, you know, being the sort of the real window to compliance. But, you know, a spike in year 15 might just be driven by the few cases in which we observe compliance after 15 years, not because there's something magical about that date. So I think, well, I really appreciate the effort. I'm not sure how much inferences we should draw just based on, you know, well, this is what the data have given us, so there must be something special about year 15, for example.
Thanks, Francesca. No, I think those are very important points, and probably some that we should discuss in greater detail later. But on the issue of the fact that those observations are not independent, if I understand correctly your point, I think of course you're absolutely right. We observe compliance conditional on the fact that compliance has not taken place before, and that is why as in every discrete time survival model, the observations drop after compliance takes place. So the sample we observe at any point in time is the sample of observations for which compliance hasn't taken place yet. Now, on the more general issue of averaging across observations, that's a very important point. In this very simple example, we do average across observations for this imaginary target, right? In practice, when we model this statistically, we need to consider frailties, that is random effects by case or by state or by reparation measure even to account for that variation that you mentioned.
And just to add to that, without taking up more time, the coding of the information, the statistical information, is also accompanied by extensive memo preparation for every case. And we'll have occasion to discuss that, particularly in regard to the World Bank Inspection Panel, where the procedures are a little bit more evolving than standardized as compared with the Inter-American Court. Dr. Steininger, I see you've raised the hand.
No, doctor, sorry. Just a short question. Thank you for letting me speak while not being doctor. So just a short question on the methodology. Mainly, what are the factors for what you control for if you're doing it across different bodies? Because of course the Inter-American Court is very specific, but I worked at the Department for Execution at the European Court of Human Rights, which is not specific at all. And then you have, first of all, you have the problem that it's not clear what, like even working at the department, you see how different states define very differently what they think they should comply with. And the second of all is that oftentimes, like we have cases like Cyprus versus Turkey now going on for 30 years. The requirements to comply are not in the effect that the court can actually do something about it, because it's just like geopolitical major conflicts and so on. So is there a number of cases you will just kick out of the sample, such as major political conflicts? Or what are basically some other factors you control for if you're doing it if you're using your methodology across different judicial bodies?
That's a very important question. At this point, we are not even daring of thinking about pooling information for different adjudication bodies. In part because of even if we are trying to have a common framework. I think that the structure of the data may even be different, right? But as you point out, there will be a lot of causal heterogeneity across different adjudication bodies. Now, even within the same adjudication body, it's clear that there is causal heterogeneity for different types of cases, different types of reparation measures, certainly different types of targets like states. And so in any, besides the very simple example I presented, in any real estimation, we need to control for multiple factors. It seems, for example, that the nature of the state is likely to be one of the factors that is crucial to control for.
My brief answer to that is the model that is used for the Inter-American Court will not be exactly identical as that which is used, because Professor Perez has adapted his model to take into account the nature of the tribunal and the proceedings that do take place. So it is an ongoing work in progress statistically to code this information. I can see we are well within good time for this workshop, and so I'm going to turn over to Anibal, who's going to facilitate the next part on institutional challenges to assess compliance, where we have the benefit of our experts from the institutions here. Anibal?
Thank you, Diane. We have, this is a very important moment for us because now we will hear from the institutions who are with us today. Fernando Sanchez at the Inter-American Commission on Human Rights, Gabriela Pacheco at the Inter-American Court of Human Rights, and Imran Jalal at the World Bank Inspection Panel. And I really, really thank you all for your willingness to be with us today and sharing your experience with us today. This is very informal, so we ask you to discuss your experience for about 10 minutes, and we are looking forward to it. Unfortunately, in this format, it will be very hard for me to give you a sense of time and to let you know how you are doing with time. So I will be rude in a way, and because I think it's the most efficient way to do it. So you will start your presentation for 10 minutes. When you have about 2 minutes left, I will just interrupt and say you have 2 minutes left. So if you are looking at your screen, focusing on your presentation, you will know that the time is coming. So I apologize in advance for interrupting, but that's probably the most efficient way to do it. So on that note, I think we should probably start. Fernanda, would you like to start? Thank you very much for being here today.
Good morning to all of you. First of all, thank you so much for the invitation to participate in this special workshop. We believe it constitutes an important space for the reflection, and it offers us a valuable opportunity to visualize the impacts and repercussions of the work of the Inter-American human rights system. I will start with a general overview of the Commission works to monitor its recommendations. And in this sense, it's important to clarify that the Commission makes recommendations to the member states of the Organization of the American States in order to promote the respect for human rights through its various mechanisms. This is one of the functions mandated to the Commission to promote the observance and defense of human rights in the Americas. And I think it's important because I will generally focus on the different mechanisms we have through the different recommendations, type of recommendations the Commission makes. Within the framework of the petition and case system, the Commission adopts and follow-ups on recommendations issued on published merit reports, decisions in friendly settlement agreements, and decisions in resolutions that grant or extend precautionary measures. The Commission also, within the framework of its monitoring system, adopts and follow-ups recommendations published in its thematic reports, country reports, resolutions, and its annual report. Since 2017, within the new strategic plan, the Commission identified that effectiveness and efficiency of the recommendation that it makes to the OAS member states are the foundation upon which it should redouble its efforts. In this sense, as a part of the strategic plan, the Commission is implementing a special program to monitor its recommendation. This program seeks to strengthen the capacity of the Commission to promote an efficient follow-up mechanism to follow up its recommendation in an integrated and coordinated manner, and also to better verify the level of compliance at the domestic incorporation of states' international human rights obligations. In this sense, the Commission put into operation in 2018 the monitoring of recommendations and impact section. The section is currently responsible for the coordination of the work of the Inter-American Commission in the follow-up of its recommendation in a comprehensive, transversal, and coordinated manner. Within this strategy, the Commission has established this plan centered around 5 principal components. The first of it is the creation and embracement of work process and methodologies regarding the follow-up of recommendations. The second, the creation and implementation of special mechanisms to follow up its recommendations. The third, the creation and launch of the Inter-American System for Monitoring Recommendations, the Inter-American CIMODI. Fourth, the ENRACE coordination with the technical and political organs of the Organization of the American State. And the last one, in terms of strengthening the capacity of the OAS member states to monitor and implement the Commission's recommendations. In this sense, considering that these workshops is more focused on the analysis of the reparative measures, I will focus my presentation on the work process and methodologies regarding the follow-up of recommendation on individual cases. In this sense, the Commission began to undertaking an analysis of its existing mechanisms to identify challenges related to the follow-up of recommendations. Some of these challenges were related to the work process that the Commission had established. First of all, and in this sense, the Commission has taken important steps in the development and improvement of this methodology for monitoring its recommendation, as well to verify the degree of compliance and internalization of the commitments assumed by the OAS member states. In this sense, the Commission embraced the categories of analysis that it used to evaluate the level of compliance of its recommendations issued by expanding the range of criteria used, including new like substantial partial compliance, and also allowing to covering invisible categories not included before, such as non-compliance. We generally need those type of category, for example, when we have death penalty cases where the states, even with the recommendations made by the Commission, execute the victims. So this is one of the improvements. Also to develop the categories to analyze the information presented by the parties, so member states and petitioners, annually when the Commission prepares its annual report. So right now we analyze if it's relevant information presented, if it's irrelevant information, or if the state or the parties doesn't present information at all. This is important because in 2017, for example, before this strategy, the Commission only received the information in around 20% of the cases that were in follow-up stage. And part of this information was repetitive in relation to previous year. The Commission also in its annual report has redesigned its annual report, in a sense that it developed previously to the preparation of the report guidelines to assist the party with the presentation of the information. It also classified for the first time in 20 years the level of compliance of each individual recommendations in its merits report and clause in friendly settlements agreements in all the cases. Also create some follow-up fact sheets for each individual case, which will now be connected to the Inter-American CIMODI. The Commission started to highlight the main individual and structural results achieved in each individual case, and also to sign the main challenge and lack of compliance or information that the state should focus on or present in the next annual report. And also to analyze the compliance based on the Inter-American standards. The Commission has also started to do an analysis and also to sign the main advances, challenges, and results achieved during the year regarding the follow-up of all individual cases. In terms of methodology, the Commission has also approved the general guidelines on following up recommendations and decisions of the Inter-American Commission, which outlines the follow-up process undertaken by its various mechanisms. And the Commission is also seeking to improve the way it recommends reparation measures to be more precise, objective, and measurable manner. This process is based on the concept of integral reparation, based on the harm suffered in form of individual reparation measures, such as restitution, compensation, rehabilitation, as well as general measures of satisfaction, guarantee, and non-repetition. In recent years, since the strategic plan, the Commission has also expanded its follow-up actions in terms of seeking for building consensus routes to implement the recommendations with the parties, to reestablish contact with the victims and their representatives and with the member states, in which the Commission did not receive information in recent years. Just to give you an example, in the last 2 years, these actions resulted in a segment increase of more than 200% in level of response of the parties. Likewise, the Commission is also increasing in efforts in holding bilateral and working meetings. While the progress has been made and some states, for example, has introduced reforms and implemented public policies to comply with satisfaction and also compensation measures, to enforce international decisions, the challenge of reaching a level of compliance is their ensured the effectiveness of the system remains. For example, the time taken to comply with the measures, the low compliance with the justice measures, the long time that the cases remain in a follow-up stage. We have cases that have been following up for more than 20 years, for example. The low willingness to comply and absence of responses of the states that not ratify the American Convention are examples of this challenge. There is a window of opportunity in relation to those cases that have the possibility of being referred to the Inter-American Court, where the states made their best efforts to establish dialogues with the victims and their representatives. It's during this transitional stage, and this is the better opportunity to have compliance with the recommendations. What the Commission has learned during these last years is that a closer and stronger monitoring process developed hand in hand with states and petitioner results in higher rates of compliance. If I have the opportunity, I'll go back to the other components of the strategy during the dialogue. And thank you so much for this.
Thank you, Fernanda. The information that the Inter-American Commission is making available nowadays is truly incredible. And I hope we will have a little bit of a chance to talk about Simore during the Q&A. Gabriela, would you like to talk about the court?
Yes, thank you, Aníbal. Yes. Well, good morning, everybody. It's a pleasure to participate in this workshop on behalf of the Secretariat of the Inter-American Court of Human Rights. We want to give special thanks to Aníbal, with whom we have maintained constant and productive communication during his work at the lab. And on a personal level, it gives me a great satisfaction to be able to greet my former professors, Mr. Carosa and Mrs. O'Connell. About the Inter-American Court and about compliance with its judgments, we must take into account that numerous measures of reparations are ordered in each judgment. Sometimes 15 reparations in only one judgment, which makes it important to assess the level of compliance of each reparation and not only the judgment as a whole. Currently, there are 225 cases at the stage of monitoring compliance, which entails monitoring more than 1,000 measures of reparations. So both the number of reparations and also their nature and complexity have an impact on the time a case may remain at the stage of monitoring compliance. We know that the degree of compliance varies depending on the form of reparation. It is not the same to comply with the guarantee of non-repetition than to comply with the payment of compensation and costs. Regarding the degree of compliance of each reparation, taking into account the complexity of some of those reparations and the number of victims in each case, the court assesses in an order whether it is full compliance, partial compliance, or pending compliance. In very serious cases, the court can also issue an order stating that the state did not comply or that the state is disregarding the reparation order. In each order, the court explains the reasons for its assessment and pronounces on what is alleged by the state and what is alleged by the representatives of the victims. In recent years, the court has identified the need to recognize progress in compliance on reparations, even if it is not partial compliance. For instance, regarding rehabilitation, when the state have been providing medical treatment but must continue to do so, the court values that the state has been compliant and must continue implementing until it provides sufficient guarantees that even when the court declares compliance, the victims will continue to receive treatment in the terms ordered in the judgment. Another example is regarding the obligation to investigate. It's not that easy to say it's pending compliance or is partial compliance. So the court has recognized when states have taken steps in compliance regarding the progress of the criminal process or the issuance of judgments. So we have another set of for some of reparations that is not as easy to say that is partial compliance or total compliance. In regard to the mechanisms or strategies the court uses to monitor compliance, over the years, the court has been expanding such mechanisms to achieve greater effectiveness. We must remember that the Inter-American Court does not work on a permanent basis. So it's very hard to fulfill with effectiveness this supervision of compliance labor when they don't hold, they cannot hold hearings or deliver orders all the time. So the mechanisms the court uses are issuing orders, holds private or public hearings, does daily monitoring by means of notes issued by the court secretariat, and in recent years, since 2015, conducts on-site visits in the state found responsible. Compliance with reparations such as restitution of indigenous people's right to land, guarantees of no repetition that require amendments to the law, changes in jurisprudence, the design and execution of public policies, and the obligation to investigate constitute real challenges for the court. Most of those reparations were ordered in judgments issued more than 3 years ago. So it is important to consider how to achieve progress in compliance considering the time elapsed. As Aníbal explained, the time window is not very in favor of compliance of these measures right now. So we must ask ourselves and must try to research if there are conditions at a national level that favor compliance, which the court must take into account to act at key moments. In those circumstances, which mechanisms to monitor compliance promote further progress? These are important issues to research. I don't have time to refer to many of them, but I would like at least to mention some. The work done by, for instance, that we have to look at the work done by interinstitutional bodies or commissions that are in charge of coordinating compliance with judgments at a national level. We have to look at changes in government. Also, there is an impact when there is interest shown by the academia and the involvement of civil society in demanding the state to comply. Also, when international cooperation is, or other international institutions are looking at the same problems that the guarantees of reparations were looking when the court ordered those reparations. Also, regarding the mechanisms, the court uses requests for reports made by the court to obtain direct information from specific state organs and institutions that have competence or a function that is relevant for implementation of the reparation at a domestic level is an important step taken in recent years. For example, we have been asking the national human rights institutions to provide information directly to the court regarding guarantees of non-repetition. Also, the on-site visits in the state found responsible. For those, we need the collaboration of the state, of course, but we have taken steps in recent years. Why? Because those visits provide the advantage of enabling the court to verify the implementation directly. They give greater participation to the victims, to their representatives, to the state official and authorities directly responsible for the implementation of the reparations. So it's not like when hearings are held at the seat of the court in San Jose which are mainly attended by the state agent and the representatives of the victims. In these visits, it also have the positive that it increases the willingness to assume commitments from the state agents, and also allows immediate communication between the victims and the senior state officials. Not the court. The court doesn't need to be in the middle of those communications all the time. So it is very important for that communication to occur directly between the persons that need to progress in the compliance. In addition, the victims' opinions on the programs and shortcomings can be heard directly. They cannot travel always to San Jose to explain the court what are the problems with the fulfillment. I will give an example of effectiveness in progress of compliance regarding the mechanisms of on-site visits. In 2015, Paraguay had not complied with some important reparations ordered in 3 cases of indigenous communities related to the right to property, related to establishing a community. Thank you. Sorry. Establishing a community development fund and housing and provision of basic services such as supply of drinking water. The judgments had been issued 5 or 10 years ago. So in 3 years, the court issued several orders, conducted on-site visit by private hearing, and it was a success regarding an advance on the execution of reparations. There was a large delegation from the state that participated on the visit, among whom were senior officials representing different ministries and public institutions. So this is it shows the result of an on-site visit. And for instance, the days prior to the visit, the state installed water storage tanks and provided drinking water for the victims. And just last year, the state provided housing to many families and made the first payments to community development funds. So I think we need to identify or create other windows of opportunity that are certainly not the window of time for these guarantees of no repetition, obligation to investigate, and to look for the whereabouts of the victims. I do not have time to refer to the formulation of reparation orders, but I'm sure the Inter-American Court will benefit from the results of the lab. So thank you very much.
Thank you, Gabriela. I'm sure that for many of us in the social sciences, the way in which the court collects, systematizes, and supervises compliance, I think has served as a foundation for how we design the methodologies to model compliance. And I think that has been my experience, and probably Francesca's experience, and many others in our field as well. So I wanted to thank you for all the work you are doing. Imrana, would you like to discuss the inspection panel?
Sure, thank you, Anibal. So the first thing we'd like to do is to show you a short video, which we think in a way best describes what happens from the time of our findings to compliance with our policies and reparations that the bank provides. So that's about 5 minutes. And then I'll spend the next 5 minutes chatting a little bit more about it in detail. So Therese, over to you if you could show the video, please. Thank you.
In September 2015, and would, for the first time, put before the inspection panel the issue of gender-based violence in a World Bank finance project. The allegations regarding the transport sector development project were serious, numerous, and wide-ranging.
During the construction of the Kamwenge-Fukuto Road around 2014 there, a lot of issues emerged from the community. There are cases of sexual abuse of young children, and that led many of them to drop out of school. Others became pregnant, others were infected with HIV and AIDS. And as a result of that, there was a wide outcry in the community.
We wrote to the inspection panel, Washington, D.C., through Joy for Children, and our message was delivered. The Uganda case was the first time that the bank was confronting gender-based violence and girls, minors that have been raped by people working for the project. So that was very shocking to everybody.
The issues were so serious that the World Bank suspended funding for the project in October 2015 and canceled it 2 months later. In January 2016, the bank's board of executive directors gave the panel approval to investigate the project. In determining whether to recommend an investigation to the board, a panel team had visited the affected communities. What they observed left a vivid impression.
Then we met with girls who were the victims of gender-based violence because the construction company brought in workers from other parts of Uganda. It's a very poor community, and when the workers come in with some money, the girls just basically go along. So many pregnant girls, like at the age of 13, 14, we met who had to leave school. It was very sad.
The panel's investigation report confirmed the claims made in the complaint and identified a substantial number of instances where the World Bank had not complied with its own policies and procedures. That included inadequately assessing and mitigating the impact of an influx of workers from outside the community and other risks related to gender-based violence.
Most of the complainants, most of the people who suffered were underage girls. And it pointed to the fact that many of the people that the bank tries to help are in fact very vulnerable. The bank is supposed to improve their lives. But in this particular case, I think we have to admit that the bank failed. But having said that, I think what I found particularly encouraging was the institution's response at the various levels after the investigation.
The inspection panel's investigation identified multiple failures, including cases of gender-based violence. The panel helped lead to the launch of the Global Gender-Based Violence Task Force, which advises us on best practices to prevent gender-based violence.
In addition to creating the task force, the World Bank issued a report on institutional lessons learned, as well as a guidance note for staff on how to deal with the temporary influx of workers as a result of bank-supported projects. A plan developed by bank management put in place a wide variety of actions to be taken both by the bank and by the government of Uganda in response to the panel's findings. Vocational training was offered in a variety of income-generating activities, and startup kits were provided for enterprises such as tailoring and hairdressing. These activities were carried out through the NGO Building Resources Across Communities, or BRAC.
Ukubazira ntitubazira n'abana bitu tibakabonabona kugira ngo inkeza amate turazibona hatiya.
The issue of gender-based violence came before the panel a second time in a 2017 case involving another roads project, this time in the Democratic Republic of Congo. And given the bank's increasing work in fragile countries facing conflict and violence, the issue may well come up again. But in Uganda, the inspection panel case and the World Bank's response to it brought redress to the community and prompted actions to address the risks of gender-based violence in projects more broadly.
I'm very grateful, first to the inspection panel, but also the bank, because these processes went hand in hand. The inspection panel was doing its work, but also the management doing its response.
We already a success story. All the issues that were negatively impacting on the society that we raised have been totally addressed. It became an eye-opener to government institutions. Immediately, the inspection panel came on ground. They started doing their work, their role. So we are happy. To me, it's really a
So,
success.
Therese, I think we can stop there. So, let me just, I have 5 more minutes to make some comments. First of all, thank you so much for inviting the inspection panel to participate. In some ways, we're a bit of an anomaly in the sense that we're not, you know, a judicial tribunal or even arguably a quasi-judicial tribunal. And the video that you saw, it was actually a good story. It led to, apart from shaking the bank to its core, it led to really significant institutional changes at the World Bank, but also a very good agreement between the bank and the government of Uganda. There were also significant institutional changes to the Ugandan Roads Authority, which was a very excellent outcome for us. So it illustrates well that reparations do occur when there's a willingness on both sides, that of the borrower, but also on the side of the bank, in terms of supporting the borrower in the implementation of such measures. Now, this type of good outcome does not always happen, of course, and challenges remain. There's difficulties of access to the panel, lack of information about the panel. There's all sorts of restrictions. Until recently, we had a time eligibility restriction where complainants had to file their case, file their complaint before 95% of the funds of the bank were dispersed. And until recently, we did not have the ability to monitor the remedies provided by the bank. So just to clarify, the panel does not make remedial recommendations per se in its investigation reports. The reports contain findings of non-compliance against our environmental and social safeguards, and then the bank management has to develop a management action plan which is supposed to respond to our findings and which is supposed to provide the remedies for the complainants. Now, until recently, we have not had any capacity, no authority to go back to look to see whether or not bank management has done what it said, or whether the borrower and the bank together implemented the remedial measures. Very recently, in the last few months, the World Bank Board has authorized us, after 27 years of existence, to verify the management action plans, and in exceptional cases, the inspection panel will be allowed to go back to the country and talk to the requesters to see whether or not the remedies provided were effectively implemented or were effective or not. So, you know, up until recently, in the last 27 years, we had no way of knowing whether or not the remedies provided were effective or not, because we had no further relationship with the requesters after the management action plan was approved by the board. The other thing to note is that in our system, the borrower and management enter into the agreement about the management action plan, and the borrower has to pay for the remedial actions. So you can imagine how many challenges there are coming out of that. Of course, it is possible for the borrower to apply for additional financing, and that has done before, but that is not always the case. So let me just mention very briefly this new tool we have. So a couple of months ago, okay, in February this year, the board has approved the inspection panel to go back to the field and to verify whether or not the management action plan is being implemented properly. So in a way, this is a new form of compliance with, it gives us a capacity to go back to the field to verify the maps, the management action plans in a few exceptional situations. So this offers a form of compliance of remedies. So in the next few years, we may be able to come back to you and say, and give you an idea of whether or not there are compliance with the remedies offered in the management action plan. The final point I wanted to make is that the international accountability mechanisms, there's about 17 of 18 of us, have often talked about banks having remedial funds with which to offer borrowers who are struggling to comply with remedies. But so far, the World Bank has not set up a remedial fund, although there's ongoing talks about it. So thanks. I'll finish there now. Thank you.
Thank you very much for this great presentation. I imagine that the ability of the panel to monitor remedies from now on, it's a major institutional change for you. I want to thank all the presentations because they were fantastic, and because all of you were respectful of the time, and I want to apologize again for interrupting you to keep time. I think we can open the conversation for a few questions and answers. You can raise your hand. If you go to participants, you have an option to raise your hand and ask questions, or you can also add your questions to the chat in order to ask any questions directly. I think Mary Ellen has a question.
I do, thanks, Anibal. This is to Imrana. Could you tell us a little bit more about the political context in which this new tool was added? I think we'd all like to know what the magic mixture was that led to this good outcome.
Well, you know, thank you, Mary. This is it was a very, very difficult process, and there was basically 2.5 years of negotiation and consensus building, and on my part, a lot of lobbying and advocacy to the 25 board members who represent the 189 countries. So you know, and this monitoring or verification of management action plans was the most difficult tool to win. We got the other 3 or 4 or 5 relatively easy, although easy is not a good way to describe it, because you can imagine 25 countries with their own geopolitical agendas and so on, right? So, I mean, you can probably guess that there was a strong resistance initially to the borrower countries who don't want to have to deal with the inspection panel as well as management, which is supposed to supervise the management action plan. So there was a lot of resistance, but in the end, because we agreed that we would only monitor in quote unquote exceptional cases, there was an agreement that to allow us to monitor, verify the management action plan. However, unlike other tribunals in the International Accountability Mechanism system, who have their own discretion to go back into the field to monitor what they want, when they want, we have to seek World Bank board approval in order to go back and monitor the action plans.
Thank you, Imrana. I think Francesca has a question as well.
Yes, thank you. These presentations were so interesting. My question's for Gabriela. I really appreciate all of the ideas that you have about ways in which the Inter-American Court can create more windows of opportunity, as you put it, for compliance. And I was sort of wondering, you know, like what capacity, given that the court is not permanently in session, does the court have to be monitoring the sorts of domestic conditions like leader transitions, or, you know, looking for those political moments in which compliance might be more likely. So I guess what capacity does the court have to implement something like that?
Thank you so much for the question. Well, what the court has been doing is it issues an order, or when holding sessions, approves the president of the tribunal or any other judge to go with the secretariat or personnel from the unit I work in, which is the unit that supervises compliance, to go to the country and do the on-site visits. So we try to use mechanisms that does not require the whole tribunal to hold sessions, because otherwise we'll not get any progress done. I don't know if your question was regarding that, or did I misunderstood? Or
no, that was a fine answer. Thank you.
Okay, and we also like every single day the secretariat also we ask for reports to the states, or we ask for information from the victims or its representatives, or we also use Article 69 of the Rules of Procedure to directly ask information from national institutions, or for example, from national judges that are in charge of executing a reparation. Maybe the state, it's saying that I cannot pay to these victims because this has to be studied by another tribunal in my country. So it's been years of that. So we asked information from that tribunal, and that tribunal said, no, I already ordered the administrative authorities to pay. So there is not willingness to pay. It's not that that I haven't done the work. So we are trying to break these problems that from international point of view, we have to ask information from the state agent, but sometimes that doesn't work, that doesn't give us any progress. So we are trying to look for other ways to obtain that information and get any progress done. Thank you.
Thank you, Gabriela. I have a question for Fernanda, if I may. Fernanda, you described the incredible work that the Commission has done recently in terms of advancing the supervision function. And I know that some of those changes are still being implemented and will be implemented soon. So I was wondering if you could talk a little bit about CIMORE and when it's going to be launched and how you expect it to work.
Sure, thank you very much, Anibal, for the opportunity to explain a little bit more about the system. This is actually a partnership that we established with the state of Paraguay after they implemented this good practice with the support of the Office of the High Commission on Human Rights. And it has also been disseminated in different countries of the region. And we also have been in dialogue with states that has different type of national systems. So the idea of the Inter-American system is basically an electronic platform that systematizes the recommendations issued by the Commission through its different mechanisms, the petition and cases one, the monitoring mechanisms, and it's also allowed the users to submit information related to the measures adopted by the member states to comply with these recommendations. So the system is basically finished. The idea is that it will be launched on June 10th. We are organizing a webinar to launch the system. The Commission is also focusing in this first moment in following up the resolution regarding the pandemic and human rights. So the system will majorly be open, and we will be stimulating the main stakeholders of the Inter-American system to fulfill and to send information regarding the implementation of the recommendations of the resolution. And we believe that the system will also be an opportunity to access and utilize useful compliance data, resulting also in a democratization of the information, and also in a process of public oversight and scrutiny, and also facilitating the active participation of third parties in the examination of the compliance. We're focusing in this first moment in receiving information in the monitoring, in recommendations made in our monitoring system, and we will connect the monitoring process of the petition and case systems to the fact sheets of the annual report. So the system will majorly be open for the monitoring recommendations. And we are also working in as a second part or stage of this strategy in the design and articulation of the impact observatory of the work of the Commission. This is also another strategy in terms of monitor and measure the impacts of the recommendations of the Commission, and also different mechanisms, not only the recommendations, but also another strategies and mandates that the Commission used to had in the Americans. And the idea is also to establish, going to the third question that you open in the concept note, in collaboration with academic networks, civil society actors, and research groups, national human rights institutions, amongst others.
If I may address the question, Anibal, to Chair Jalal, thank you very much for the presentation. I'm very intrigued by the February 2020 decision. Part of the participants in this class actually were the very first group of Notre Dame students who have gone through the jurisprudence, or I should say the reports and findings of the inspection panel since its inception to the latest date. And what was so interesting in trying to make sense with the evolving procedures and nature of the reports being generated by the panel was that it was only in more recent years that the panel got more and more specific about its findings in regard to project compliance with the bank's environmental and social standards. The question that I have is, will the new decision for the panel to be able to go back to the field to verify the management action plans include possibilities to refer back to the requesters? Would there be a routinized process by which they can provide information as well to the inspection panel?
Yes, thanks for that excellent question, Diane. Yes, absolutely. So we would verify implementation of the remedies by talking directly to them. I mean, in theory, they could, even now, before the new tool was authorized, they could come back to us and tell us that, you know, the management action plan wasn't being implemented. But aside from using back channels to provide this information to management, we really had no formal authority. So with this new tool, we will provide a report to the board. So this is, you know, I mean, we have a very conservative board, as you can imagine. This report will be a way for the board to hear the requesters' voices about how effective the remedies have been on them. And presumably from that, I mean, it's a bit of an experiment in the beginning because we haven't done one yet. Presumably based on that, there will be new directions given to management about which actions have been implemented or not. But, you know, one of the arguments I use with board members about having the authority to monitor, verify, is that this is a huge incentive to management to make sure that its actions are being implemented. So just the kind of having that moral authority, if you like, the possibility that the inspection panel can go back, I think is going to be a very effective way of making sure management does its task. And can I just also make a general statement? You know, so the panel's been going for 27 years, and I have to say that on the whole, the board takes our reports extremely seriously. There's never been a report rejected by the board, which is theoretically possible and has happened to other mechanisms. And management does keep on its toes whenever it comes to an inspection panel report and the findings. So, you know, whether we'll find any more details now, it remains to be seen, but I'm looking forward to it.
Thank you, Imrana. I think Sylvia has a question as well. Sylvia?
Thank you. Just a short question. Thank you very much for those three very, very insightful presentations. I learned a lot. I just have a question now to the organizer after hearing those three presentations, because I found that the common thread through all the three presentations was the involvement of civil society, of ombudsman persons and institutions providing information, also bringing the attention to those cases. And for this, I was wondering if you're also accounting for the involvement of civil society in your methodology. So is there any way you can measure how civil society is pushing or at least shining a light and bringing attention to particular cases, and thus, for example, also accounting for this like big spike in compliance in some sense? So is there any way you can control / measure the involvement of civil society in the compliance rate also over time, of course?
Sylvia, I think that's a wonderful point, and I think this is, based on this conversation, this is one of the things we need to work very seriously on. Of course, thinking about the involvement of civil society for a large number of cases over a number of years, over a long period, it's going to be a challenge in terms of collecting the information and measurement. But it potentially could be done. I suspect it would require collecting a lot of information with the different organizations involved, in the case of with the requesters or the representatives of the victims. So So I think it's going to be a challenge. I'm not sure we will be able to do something like that systematically for all cases we study for all tribunals, but I think this could be a very important project for at least some of the cases. So I hope we will have a chance to talk about this in more detail.
And to add to that, in fact, this factor was precisely among the factors that were identified by the students in the Human Rights Reparations class this spring. The nature of the intensity of the advocacy and the effectiveness of backdrop political movements, social movements in regard to pushing forward specific reparative claims has also been noted anecdotally in various individual cases, but has not yet been measured thus far. Anibal?
No, and I wanted to also mention that there may be some indirect ways to measuring how civil society, the positions of civil society or the general orientation of civil society. In Francesca's work, for example, she has used public opinion to capture some of that. But I think this is clearly something we need to work on. I think there are no more questions at this point. So we have covered a lot, and this has been a fantastic conversation. I really want to thank you all. It may be a good idea to take a few minutes as a break. So maybe we could take a very short break and reconvene in 8 minutes, say at 12 p.m. Eastern time. That would be 5 p.m. in the UK, and I guess 10 a.m. in Costa Rica. Okay.
Thank you very much. We'll see you in 8 minutes.
And we can move to the next section.
All right. Thank you very much to all the participants for an excellent first session. Just to continue to the last half of this online workshop, we will now focus on extending the approaches on compliance and reparations to other tribunals. And for this purpose, we have invited experts, especially international law experts and political science experts, to look at various conceptions of the 3 questions or challenges that we have put forward in the concept note with respect to designing compliance and reparations in different fora. So for this initial session on human rights per the schedule, we have Professor Marko Milanovic, Dr. Parente, unfortunately, Professor Adriatza is not here, and then we will have Professor Nicole de Silva. So all of the speakers have been given their respective times. I will do the exact same thing Anibal does, which is to tell people when they're past their 5-minute mark and to cut off and move to the next presentation. But otherwise, we are within good time. Thank you, Marco.
Thanks. I thought we were only speaking for a couple of minutes anyway.
Yes, of course.
Well, thank you, Diane, for having me, and thank you, Anibal, as well. It's a pleasure to be with all of you. I hope what I have to say will be somewhat useful, because I'm neither an empirical person or a rigorous person in measuring things very much. But speaking mainly from a European court experience, what I found very useful in thinking about compliance with judgments is compliance in your sort of routine type of case, where compliance is mainly a sort of technocratic issue, and where measuring it is also a technocratic issue. Obviously, that is a very big question about how do you inculcate in, I don't know, the officials in Serbia or wherever, I'm picking a random example, a desire to respect, a commitment to the European Convention on Human Rights, a desire to take action, and so on. But then there's those cases that are often not routine, that are very highly political. And I don't know how you intend to do these, how to deal with these in your project, because compliance in these cases is a completely different sort of kettle of fish than your normal case. And there's one subcategory of these cases, let's call them politically hugely controversial cases, where you need to expend an enormous amount of political capital domestically to actually achieve compliance. But there's even a narrower subset of these cases which actually require constitutional level reform. And that normally entails not only some political capital being spent, but some kind of political supermajority within a state. And those are the most difficult cases. Sometimes they happen reasonably quickly, sometimes they don't. So one case that comes to mind sort of immediately to me is this case with which some of you may be familiar with, which is called Sejdic and Finci versus Bosnia and Herzegovina. And that's a case that was decided 10 years ago. The sort of 10th anniversary was in December last year. And that dealt with the inability of people who do not self-identify as Bosnian Muslims, Serbs, or Croats to stand for elections in Bosnia for the presidency and the upper chamber of parliament. And the reason why this is not possible is because of the Dayton Peace Accords, which sort of created a consociational arrangement between these three groups. And I think it's a hugely instructive case study for you guys, because you could see that there was some kind of window of opportunity in the initial few years after the judgment. That window of opportunity was missed and lost. And now 10 years later, there's nothing. No real movement has been made towards compliance. And the reason why compliance is so difficult is that it actually requires amending the Constitution. And to amend the Constitution, basically you need all these three groups to agree. And compliance has not been possible, even though the European Union told Bosnia, if you do not comply, there will be no progress, not real, or your progress will be much slower towards EU integration. So I think that's a very instructive example. A more positive example I can think of in a country which was not then, certainly not now, a paragon of democracy, is actually a change in constitution in Turkey. 20 years ago, Turkey had those national state security courts, which had military judges and prosecutors, which could try civilians. And in two judgments, I think this is 1998, the European Court of Human Rights said it's a violation of the right to fair trial to have military judges and prosecutors try civilians. Even now, mind you, the sort of composition and jurisdiction authority of these courts was set out in the Turkish constitution. And then, if memory serves, at the beginning of 1999, Abdullah Öcalan, so the head of the PKK, the most wanted fugitive in Turkey, was arrested. And then, knowing that, like, if they try him before one of these courts, that this will immediately go to the European Court of Human Rights, that it'll prove a disaster, the Turkish National Assembly actually changed the constitution of Turkey to abolish the jurisdiction of these courts over civilians. So that happened in a span of months. So if you think of so they complied with some prior judgments of the European Court, which were decided sort of 6 months before that. But the reason why they complied with was anticipatory, which was the Öcalan trial, which was then yet to begin. Now, clearly, like when you do an empirical project that cannot capture the qualitative sort of nuances in a case like this one, right? It's very difficult to do, by design. But again, it has this temporal dimension, and it is one of those hugely politically controversial cases, and they did it. Sometimes, I'm wrapping up. Sometimes it's interesting to see how there's a proactive violation of the convention without any judgment, really. So I don't know whether you saw how Hungary recently passed a law which denied legal recognition of gender change to transgender people. And this goes against both the jurisprudence of the European Court of Human Rights and of the Hungarian Constitutional Court. And they did it now after the state of emergency and so on, simply as sending a signal. So it's a kind of prospective non-compliance, which is kind of weird. It probably does not figure in your project, but still, it's that type of political sort of dynamics that somehow need to be captured and reflected in, because as I said, there's a very big difference between a judgment where it says, Serbian courts are not efficient enough and people are waiting for trials for too long a time, and how you're going to comply with that, as opposed to cases like these. And somehow you need to deal with that. Thanks.
Thank you, Marco. We now turn to Francesca.
Hi. yeah, this discussion has been really great. I'm really looking forward to collaborating further and hopefully meeting in person one day once, you know, the world has stopped coming to an end. A lot of, as Anibal has intimated, a lot of my work on this question has revolved around the Inter-American Court of Human Rights. A lot of the ways that I've thought about compliance have been driven by the way that the Inter-American Court has treated the individual orders within cases. But I think in terms of proposing a new question, I want to turn to the Inter-American Commission, which I think certainly from a political science perspective has been understudied. I cannot think of really any papers that focus on the work, exclusively the work of the Commission, from an empirical, quantitative standpoint, and certainly not in terms of modeling compliance. One thing that was mentioned in Fernanda's presentation about compliance with merits reports, in that window of opportunity created between a preliminary merits report and a, you know, and then like 6 months, I think it is, before the case is either supposed to stay at the commission or be referred to the court. One of the things that I've been thinking a lot about is the way that the commission's institution is designed, and the way that certain cases get funneled to the court and other cases get, you know, settled, other cases stay in the merits report stage. Merits reports either are or are not published. And I've, in some of my other work that I'm currently doing, I've focused on the 2001 rules of procedure change in the commission that really clarified the way in which cases would move to the court in instances of non-compliance. And so one of the things that I would be interested in doing is sort of investigating whether that worked as intended. I have some suggestive evidence that it did, but in terms of the compliance perspective. So what that would mean is comparing the compliance outcomes for states that are under the court's jurisdiction in the period prior to 2001, say 1992 to 2000, and taking the recommendations from the merits reports of the commission that were published during this stage, which is something I've spent the last several months coding. So I think I have the complete universe of such orders, versus the merits reports and that get published after the 2001's rules changed, sort of the same thing. What were the individual recommendations? How many of them did the state comply with? Did they comply with them faster? Are they more likely to comply with them in total overall? Again, also a universe of case of, you know, I have the universe of these recommendations as well. And Anibal and I are collaborating to make sure that we have an identical universe of such reparations, so we're really understanding what the commission does, and we sort of, you know, before anyone starts moving forward in terms of, you know, going down the rabbit hole of coding, you know, chasing down compliance outcomes, that we know what the set of all recommendations were the commission was asked. And so I guess sort of the next step of this, now that, you know, the universe is established, is figuring out, well, how much compliance was there in each year after the merits report was given. And that, you know, while the commission has started, you know, and the fact sheets that were published in 2018 are very useful for a lot of cases, all of those are, like, 1999 is the earliest one. And so this would entail a lot of detailed work going through all of the annual reports, where the commission used to have, the way they used to do the monitoring of compliance, where they sort of discuss what happened in the case. And I think, you know, it is possible to still sort of capture the different recommendations and what was done. It just takes a lot more, it's a lot more time consuming on the part of the researcher, because I think we have to infer it for ourselves. Although I guess if the commission had work, you know, I don't know, somewhere that's not public, where they have gone through all of the recommendations, that would be certainly a useful contribution to save us or the undergraduate RAs who eventually get this task a lot of time and effort. But that's sort of where I see one new application for where this, you know, sort of model for discrete time analysis, duration analysis, and these specific recommendations could be applied.
Thank you very much, Francesca. We will now move on to Nicole, who will discuss the African Court or the African Commission.
Yeah, so to make the most of my 3 minutes, I am going to do a PowerPoint.
You do have 5 minutes.
Okay, great.
We have one speaker is not available.
All right, so I thought I'd start with a little bit of background on this court because it might be less familiar to a lot of you, as it's one of the newer, or it's the newest regional human rights court. So it's the African Union's Continental Human Rights Court. It's been operational since 2006, but it's been only rendering judicial decisions for about 10 years or so. It has 30 member states officially, but the majority of its cases, the vast majority, come through direct individual and NGO access, and 9 currently, soon to be 6, and I'll get to that later, have granted this access. So it's quite limited in terms of states that we're talking about. So the running kind of tally that the court has on its website, which is probably out of date, is that there's been 272 applications in total and 90 have been finalized. And you can see the breakdown according to the applicants and how noticeably the African Commission has not referred many cases to the African court, and it's very dominated by individual and NGO access. So on to reparations. Given these small numbers I'm talking about, I kind of went through the different judgments, the finalized cases, and counted 12 reparations orders against 4 states, and those started in 2014. So the focus has been Tanzania, which is the host state, and that accounts for the vast majority of the court's cases. Also, Burkina Faso has 2, and Rwanda and Benin. So we're really talking about a few states here in the grand scheme of the African Union, which is 55 states. So in terms of compliance, there's been partial or full compliance with the first 3 reparations orders. So Tanzania was partial, Burkina Faso, with its 2 orders against it in total, it complied fully with both. So that's an interesting phenomenon. But there's a kind of temporal dimension here because there's been non-compliance since then. So because we're talking about a short time frame, it could be pending, but as I'll get into shortly, the indications are that there's active resistance to complying with the court. So officially, the mechanisms for promoting compliance the court has is through reporting to the African Union Assembly. So it reports on the status of compliance with decisions, and that's the main mechanism. So the sort of elephant in the room these days with the African court is that states are progressively withdrawing those declarations that grant individual and NGO access to the court. So Rwanda was the first in 2016. Tanzania announced its withdrawal in November last year. And then just in April, last month, 2 more states, Benin and Cote d'Ivoire, announced their withdrawals. So this is impossible to ignore when we think about things like compliance, right? There's a broader political context going on here and sort of movements against the court and almost like a snowball effect going on. So, I mean, I could get into that further in the Q&A if people are curious, but I did some work kind of compiling the few initial decisions where there was partial or full compliance. So with Tanzania, that was the first reparations order the court issued. It was non-monetary. I'm using the categories in the concept note. So non-monetary, involving publishing the judgment, non-repetition, and it was a kind of short window where we have partial compliance, I mean, the sort of low-hanging fruit, let's say, of publication in 2016. Burkina Faso is an interesting state with international courts in general, with the International Criminal Court, for instance, with the African resistance against the ICC. It has been fairly vocal in supporting the court. So if the African Union makes a resolution against the ICC, it'll abstain. So it was interesting for me from a kind of comparative court's perspective to see that Burkina Faso has been fully complying with the 2 reparations orders that were made against it, both monetary and non-monetary. So this is deemed full compliance according to the African court's annual reports. So it's, you know, things like damages for material and moral prejudice, publishing the judgment, non-repetition, and so So this is a kind of initial cut of the partial or full compliance decisions. Since then, as I said, there hasn't been compliance with the decisions. And all of those states that there have been orders against, they have announced their withdrawals, or those withdrawals have come into effect. So basically there's mounting resistance against the African court. And, you know, looking at reparations is one dimension of that, but it's really impossible to ignore this broader context for compliance decisions.
Thank you very much, Nicole. Let me just...
I'll stop sharing.
Thank you. We are actually very good on time, so I will proceed immediately to the next set of speakers who will focus on questions relating to courts of general jurisdiction, arbitral tribunals, and international criminal tribunals. Christian DeVos at the OSF was with us earlier today, but has childcare duties to attend to at the moment, unfortunately, and thus will be sending us by email his preliminary thoughts on collaboration in regard to international criminal tribunals. Let me turn over to Mary Ellen.
Okay, I'm going to make sure that I stay pretty close to 3 minutes, despite our little bit of additional time. I have 3 points to make. One is about general reparations and compliance, design of reparation and compliance. The second is on International Court of Justice compliance, and the third relates 1 and 2, and hopefully to the project more generally. It's very important what you're doing. The whole idea of design throughout the law is under-theorized, underappreciated. The aesthetic aspects and values of law are just waiting for us to explore. We've seen, it's an old area. It's surprising really that we haven't done more with it. Fisher, Roger Fisher, the Shays, Antonia and Abram, and even Tom Frank to some extent, looked at how clarity of law, how law is designed can attract compliance. They were working on observation and intuition. You're adding the empirical piece. So I think we can, through your project, really advance this whole underdeveloped area to the good of law in general. The one controversial part of their design work that certainly I've been commenting on for a very long time is the interrelationship between, or perhaps the risk of an over-focus on design and an under-focus on fidelity to law. The idea that if you shape the reparation, if you shape the remedy to attract compliance, you might be undermining what gives the obligation to comply its power in the first place. So that's, I think, the critical central theoretical danger in work, any work on design with regard to compliance. The International Court of Justice has had 178 cases. The record of compliance is mixed, as I think everyone knows. I thought I would just very quickly compare the first 2 decisions of the court and the most recent 2 final decisions of the court. It happens to be that in each case, there's 1 contentious case and 1 advisory opinion. So the very first decision is the Corfu Channel case in 1948. Albania is ordered to pay reparations to the United Kingdom. They refuse to do so. The United Kingdom persists in trying to get those reparations for decades, and only finally does get reparations. It got its payment when they regularized relations at the end of the Cold War. The other decision is maybe surprising to people if they think back at it. It's the advisory opinion in the reparations for injuries in the service of the United Nations, well-named case for our purposes. And in that case, we are always hearing advisory opinions are just, I'm sorry, I should have stopped. the advisory opinion in the reparations case, Israel is found that, or the UN has found that it can bring a claim against Israel. Israel pays the claim, which is growing out of accusations of terrorism and assassination of a UN civil servant, Count Bernadette. So that maybe is surprising in light of contemporary. So fast forward to the most recent contentious case, India-Pakistan, and the most recent advisory opinion, the Chagos Islands decision. India-Pakistan are right now, just May 10th, they've just had a back and forth over compliance. Pakistan says it has fully complied, and it has done at least partial compliance because it allowed consular access to Jadev, which was the point of the case. And it says that it's working out a process to completely fulfill the consular relations obligations that the court ordered. India, however, is saying that Pakistan has not complied at all because they want a different outcome than the one the court ordered. They want the release of Jadev. And they are really playing this, and I think to some extent to the detriment of the court. The other advisory opinion is, the other case is that nobody expects, I mean, Marco can say something to everyone about this from his vantage point, but I don't think anyone expects the UK to withdraw from Diego Garcia. That leads to this third point, for which I have no time, but I'll just reiterate the problem and the relationship between fidelity to law and designing a reparation that will will attract compliance. My last word would be, especially with the International Court of Justice, the idea of what compliance is so important. There are the parties before it, and of course the General Assembly and the advisory opinions, but the court's impact on the law in general is perhaps its greater value. So if it's thinking narrowly about how to get compliance in this particular case, it may therefore undermine the more important work it does in supporting law in general. I don't know if the project can capture that as impact on the law of a more subtle and nuanced kind than the narrow kind of reparations we've been talking about so far.
Thank you very much, Mary Ellen. We'll certainly take a look at all of these questions, especially when we wrap up and move forward with the trajectory of the lab's research. Let me now call on Emilia as well. I think we'll also be dealing with questions involving the ICJ.
Yes, thank you. So I'm actually, for the last week, I've done a lot of research how to contribute to this project. I have a brief comment about the ICJ, and then I'm going to move actually to the Permanent Court of Arbitration, which I think would be even more appropriate to add to the project. So as far as the ICJ, my research has focused on resolution of maritime and territorial disputes in the ICJ. And some empirical analysis show that 88% of cases, territorial disputes since Second World War, have seen compliance in the ICJ, which is really astounding. But what some disputes, territorial disputes in the ICJ also demonstrate is that states can comply for a while and then renew their territorial claim. And we see it especially, the case that comes to my mind is the Bahrain and Qatar dispute over Zubaira Island and some other small islands in a township of Zubaira, where recently Bahrain have renewed its territorial claims. So even though both parties complied when the judgment was issued, now we see again raising of territorial claims. Now I'm going to, with this, move to Permanent Court of Arbitration in my short time, which I think is a perfect institution to engage, to be engaged with in the context of the lab. Why do I think so? Well, PCA provides a framework, a Permanent Court of Arbitration provides a framework not only for interstate arbitration, but also investor-state arbitration. And the website of the PCA provides an amazing source of information on the party's written submission, on procedural documents, on award, and also names of arbitrators. So we can actually measure compliance over time with the specific decisions. The reason why PCA constitute this really interesting case for us is that we can see whether the reality that the parties can shape the dispute resolution. So in arbitration, the parties can elect arbitrators. They can also stipulate what sort of sources should the panel use when making a decision. So for instance, the parties can stipulate that an arbitration panel needs to focus not only on international, but also some other specific sources. So the parties can shape arbitration much more so than in the context of adjudication via the ICJ. And an interesting question would be to ask whether in cases where parties indeed stipulated or outlined how the arbitration is to proceed, do we see more compliance? Or, as Mary Ellen suggested, is there something more to compliance than just mere design? So the influence on parties on the outcome and the procedure itself. Furthermore, PCA really provides on its website information on who the arbitrators are. So there are specific rules in which the parties can pick who they want to be on the arbitration panel. And an interesting question to ask would be, if we have a certain set of arbitrators that maybe are somehow related to the parties in coming from the same region or so forth, do we see a bigger compliance? Moreover, arbitration can take place by a single arbitrator, and of course, the more collegiate bodies are popular. So is it possible that we see bigger compliance when we have a more collegiate body, more people are making a decision? Does it make the arbitration award more legitimate in the eyes of the parties? That's all.
Thank you, Amelia. And just in time, we have the editor-in-chief of Oxford Investment Claims coming up. Freddie, do you want to come up and discuss arbitral tribunals?
Absolutely. Let me start my timer so that I have an idea how much I'm talking. Thank you so much for having me along. I come both at this from an academic perspective and from the perspective of an active participant in these proceedings. So part of what I wanted to address was what we heard this morning and how this might apply in the international arbitration context. So we heard this morning from Gabriela that one of the problems in the human rights context is the non-permanence of certain bodies. This is a problem that we have in arbitration on steroids, in as much as arbitral tribunals are ad hoc. So where we find a greater willingness to engage human rights is in the interim measures context. And the reason for that is that the body is still able to monitor its own compliance. So as Chair Jalal told us this morning, the monitoring and verification of management action plans is one of the key tools that is available, and that tool remains available in ad hoc arbitration to the extent we're looking at the interim measures context. And there you find a willingness to be more flexible with the kinds of remedies and the kinds of reparations that are ordered. So the cessation of criminal proceedings is something you will find in an interim measures context, but not in a final award context. Why is that? So one of the things, Sylvia mentioned the importance of civil society involvement. Interim measures frequently involve counsel pressuring a lot on the civil society side and using interim measures awards in order to move political actors and civil society actors. That is less available in a way, somewhat paradoxically, with the final award, because there's nothing to pressure towards. I think one of the things that we can see is that there is a significant underpleading in the final award context, in part because parties self-censor. So if I'm a counsel in a proceeding, I would want to ask for a remedy that I think a tribunal may offer me, rather than to overshoot. So I self-censor in a way that undermines fidelity. And I think one of the ways that we can overcome that, because I think Mary Ellen made an absolutely crucial point, is that this is an evidentiary issue. If we present better evidence and different evidence to the evidence that we have so far presented to these tribunals, we will get meaningfully different results. And I think that is where the flexibility that Emilia mentioned is key to understanding as to how what we're doing on a design side needs to be implemented by counsel in the proceedings themselves, and then needs to be done in such a way that we maintain fidelity as well as, you know, broader compliance with the orders that as made, a broader compliance with the orders as they should have been made. So a little bit long, but.
Thank you very much, Freddie. Now I see we are only 5 minutes. That's a remarkable feat given this is an online workshop. We're only 5 minutes past the hour. I'd like to give the floor back to Anibal to see if you have any further comments going forward, because this is our initial meeting as the lab. We do hope to be able to host the in-person meeting that we wanted to host this spring, where we will have the fullest opportunities to discuss, especially many of the points, all of the points we've taken note of in this meeting, but in particular, just for some last minute housekeeping rules, we very much appreciate the fact that everybody brought their insights, very provocative insights for furthering the work of the lab. Perhaps Anibal, just to close on last steps going forward to the next work, to the ongoing work and collaborative work of the lab.
Yes, I want to second Diane in that this has been an incredible conversation, and we really thank you for these fantastic ideas. I actually think that we need 6 hours to discuss all the ideas that have been presented, but having been in a couple of 6-hour Zoom meetings last week, I realized that it's not a very good idea. So I think I propose the following plan to move forward. We will collect all of...
There's a...
Sorry. Diane?
Thank you, Diane. I raised my hand. It's probably an idea that Anibal is gonna suggest. I wanted to suggest that, and I haven't ran this by Imrana. It just was about the texter, and I thought you were gonna talk about next steps, and I thought maybe I mean the panel would always be available to collaborate more with the laboratory, and maybe I'll take advantage of this moment just to mention something about the specificity of panel findings and jotted down some ideas. And you mentioned, Diane, earlier that it hasn't been always the case that panel findings were specific. Panel findings.
I'm afraid you're muted, Serge.
Sorry, I received a call in the same time. They have been specific because the specificity of panel findings stems from the policy itself. So, of course, there was an evolution in the policies, and there is an evolution that mirrors the evolution in the panel's reports. But often it is the case that since we're dealing with governments, it is preferable that findings remain at a level of vagueness or ambiguity to give the opportunity, especially if we have the indication from management that the borrower is responding to the finding of the issues raised. So, so just wanted to mention that and offer, of course, collaboration of the panel in the laboratory. Of course, I'll leave that to Imrana to decide more how we could participate. But it's definitely something that would definitely be of interest for the panel. Thank you.
Thank you very much, Serge. That's definitely of interest to us. You might not have seen them, but you have a bunch of students from the lab who have been reading the inspection panel decisions and writing their memos. This would definitely be an exciting opportunity. Anibal, I'm sorry I interrupted. Please continue on next.
No,
steps.
I think this is wonderful. I just wanted to say that this has been an incredible conversation. So unfortunately, we are over time, but I think what we are going to do is we are going to collect all of these ideas, prepare a report, and then share the report with you. And then we will follow one-on-one with you to see how we can collaborate on those ideas, how the lab can contribute to the projects you have outlined, in which ways. And then our hope is that eventually next year, as Diane mentioned, we will have another meeting in which we will see how these projects have evolved. So we really, really look forward to this project evolving.
But for sure, hopefully next year it will be in person. Hopefully it will be in person. We will also invite those who have raised questions, those who also might have an interest in collaborating on different aspects of the project. Please reach out to me or to Anibal. We will be collating all of these ideas and for sure sending out a dedicated timeline, because everything we do in the lab is run by a timeline, and we are trying to make sure we produce our deliverables on schedule. But that said, we do want to thank everybody, all the experts present today, the students from the lab who participated. Anibal, thank you very much for collaborating, even from Portugal, because he's stranded over there. And also for everybody who made it to today's session. It was extremely informative. And as we said earlier, the recording of this video will be made available by the Kellogg Institute. Thank you to everybody, and please do have a good rest of the day.